with giving plaintiffs an opportunity now to close the gaps in their case, in holding this case in abeyance. My client objects to holding this case in abeyance or staying it. My client would like the court to go forward on the trial record and issue a decision. As for the NTP review, whether monograph, whether it gets published or not published, draft or not draft, bottom line is that it would be inappropriate at this time for the court to consider the new monograph in a vacuum outside of the context of the rest of the evidence and without the experts having the opportunity to look at that and understand what all that means, especially if it's the case that the NTP review offers a decision in the context of community water fluoridation, which is a possibility. And so that context is going to be important for everyone to understand, regardless of what the bottom line conclusion is. And that is why EPA in October of 2019 came to this court and to plaintiffs when the original monograph draft was issued and said, let's hold on a second, let's look at this. Let's let our experts look at this, let's figure out what this means. And we asked everyone to pause and give us an opportunity to do that. Plaintiffs opposed it, and the court agreed with plaintiffs and decided, no, we're going to go forward with the record as it is. So at this point, post-trial, we would completely object that the court would consider the monograph in a vacuum outside the scope of all the evidence that was presented and without having our experts have an opportunity.
I've never said anything one way or the other about in a vacuum. I'm just saying I'm going to leave the record open for the limited purposes of taking into account, leaving the door open for intervening new evidence that will include the NTP in all likelihood. And that may mean that we hear more testimony from experts. And we can talk about that. I don't want to hear 10 experts, but I'd like to hear from a couple of experts on each side, one on each side perhaps, about what this means. So I'm not going to just take this NTP and go into a closet and read it and then come out with a conclusion. I want to know more about it. But it's simply on an issue this important where there are, I think, serious questions raised, but not without, potential issues within issues here, that the NTP study, I think everybody agreed here that the NTP enjoys a high degree of respect and stature in the scientific community, that this is their, area that they're looking at that is within their historic expertise. They're using systematic review, which nobody doubts is at least that's the best methodology. It may not be the only methodology, but it's the best available at this point. So, and it may be that we have to have some more testimony. I don't know yet. I'm just saying that is another reason why it makes sense, frankly, to spend this time allowing the agency to take a second look, allowing the plaintiff to straighten out the standing issues, which I also think are very serious, as I mentioned. And then if we have to come back here, if the agency does not take any action and the plaintiff decides they want to take it up, there'll be a mechanism. I mean, we could formally require you to file a new complaint, and then I consolidate the cases, or you just simply amend the complaint. Frankly, I don't see why one or the other has to be done. The simple way is to amend the complaint, but that does mean that there may be yet still a standing challenge. There may be other, other issues that when you amend a complaint, that does open the door for some pleading work. But as far as the trial record, that trial record still stands, and I would admit only things that are necessary and warranted in terms of any reopening.
Your Honor, in terms of two questions. One, would the court consider oral argument on the standing issue as it has been presented to the court? Because I do believe that the case law is strongly on our side for having met our burden. So we, just to I would, to the extent that the court would entertain oral argument, we would certainly welcome that opportunity.
Okay, the answer is no. I've looked at it and I understand it, and I'm just telling you that there are serious questions, and I'm not going to be convinced that there's not serious questions, and that's why one reason why I'm going to put this case in abeyance until the plaintiff goes through the petition process.
With respect to the NTP, Your Honor, what is in terms of a time frame on that, is the court's interest here the revised monograph that will be released in October, or the finalized version when that comes
Well,
in?
I don't know yet. I mean, obviously, the finalized version is what's going to be the most sort of dispositive. An interim monograph, you know, it may not have the same force and effect. On the other hand, it may not be irrelevant. I mean, substantively, it's going to contain, I assume, some explanation and some analysis. And what I intend to do is we can schedule a status conference, because it's not like the case is dismissed. The case is still here while you're in a parallel track. And that's going to take at least, you know, however long it takes for you to put together a petition. And then the EPA has 90 days to respond. So, you know, we could schedule something out into, let's say, October, maybe after the NAS has their first meeting. Well, maybe we'll know a little more at that point. We can schedule a status conference in November, and by that point, your petition will hopefully, presumably, be well on its way, and we'll see where that's at, and talk about case scheduling from there. So that's what I'm going to do. I'm going to hold the case in abeyance now. I'm going to indicate that I'm open. I'm going to reopen, be willing to reopen the evidence for things that arise, intervening developments, intervening studies, intervening things, and if necessary, to resolve any standing or jurisdictional issues, if there's some pleading questions or evidentiary questions that need to be looked at, not on the existing members. And if you come back with the same people, that's not going to, but if you come back with a different approach, and there are issues there, then, and that raises, you know, evidentiary questions, so we may have to look at that too, but I'll make that judgment when we get there. And then let's set a status conference for November. Angie?
November 5th, Your Honor, 10:30.
Okay, November 5th at 10:30.
Oh, and one bit of housekeeping, Your Honor, I forgot to mention.
Yeah.
I've been in contact with Mr. Doe from opposing counsel about, we have identified some errors in the trial transcript, and we've had some communications about it. We were thinking of filing something with the court to identify them, and maybe make a request to the court reporter to check the audio and make any necessary corrections. Is that a process that the court, is that something that, should we be submitting that to Your Honor, or should we be communicating directly with the court reporter? Is there any preference from the court?
I think what you should do is reach a stipulation about the corrections, and just list all those, and that way it'll be in the record. You can file that as a stip, and then we'll have I assume the court reporter will also then correct the record in that regard.
Just to clarify, Your Honor, I think that for some of them, we might know, we might be able to stipulate this is what the word should be, but for other errors, we would actually need the court reporter to go back and listen, because we're not sure what was said.
Yeah, I mean, you can ask her to go back and look at it, and then reach your stipulation, hopefully. Hopefully, there's not going to be a need for me to adjudicate, you know. I think you all can figure that out with the help of the court reporter.
Yeah.
And just one master stipulation to correct the record. That would be helpful.
That should not be any problem, Your Honor.
Good. All right. Again, I understand that, you know, there's a gap here in terms of the potential approach to this petition, but I am going to urge, number one, that the plaintiffs do what you can, not only to address standing issues, but to the extent you can provide whatever you can. You know what they want. Maybe you can't provide all of it, but I would provide as much as you can that you're comfortable in doing. And if that means the underlying calculations of Dr. Grandjean, which has some extrapolated data, it seems to me that ought to be presented. And with respect to the question of systematic review, my view is that you can do a lot in terms of trying to meet many of the elements of systematic review, such as an evaluation and an explanation of the weight given to, the various studies. You've almost sort of done that in some of your filings here. You might want to look at that and see if you can do it in a way that if not gets to the T, at least close to what a systematic review might look like. And I would urge the APA not to exalt form over substance, that to the extent that all the key elements of systematic review are there, that the agency consider that. I hope the agency does not insist that it will not do anything absent raw data from places that it can't be had from, like the Canadian study. I think that would be a real mistake, and not in keeping with the effort to try to make an honest determination of the scientific evidence here. I mean, I understand the value of that, but it is evident that some of that just cannot be gotten, and I hope that is not a precondition to meaningful review. But with that, I'm going to allow the plaintiff to go back, file a new petition addressing the issues that I mentioned, keep this case in abeyance, and leave the door open for new evidence that may develop in the interim. And so we'll see you back here at the status conference on November 5th.
Thank you, Your Honor.
All right, thank you. Good luck.
Your Honor, we have one more case this morning.
Okay.
Wong versus City of Clear Lake. Please raise your hand. If Ms. Jane Wong is an attendee, please raise your hand right now.
Ma'am, this is Shane Larson with the defendant. I did receive an email from the plaintiff saying she's having a hard time joining approximately an hour ago. I told her to keep trying, as I understood that there was going to be an increase in capacity. I don't know if she's attempted since then.
Can you send her, thank you for that. Angie, can you send her another quick invite and see if that works?
I will, Your Honor. Okay, I just sent Ms. Wong an invitation.
Okay.
If she follows the instructions, she should be able to come
Okay,
into the panel.
we'll wait a minute here
And if I may, not to interrupt, I did just attempt to call her cell phone and texted her as well.
Okay,
Hopefully that
thank you.
answers.
were you able to contact her or no?
She did not answer her cell phone.
Okay.
The recording has stopped.
Okay, I'm scanning. Why don't you make the call one more, make the announcement one more time in case she's in the audience, Angie?
I'm sorry.
Miss Jane Wong, if you're an attendee, please raise your hand at this time. The raise hand feature is.
Matt, she's just called my cell phone. She says that she can hear your voice, but for whatever reason, she's unable to get your attention, is how it's being conveyed to me.
I saw a raised hand just a few minutes ago, but it is not raised anymore. So if you could raise your hand again, Miss Wong. Your raised hand feature is at the bottom of your screen.
Is she by chance JTW24? Oh, somebody's raising their hand, looks like.
Let's see.
Yeah, Jenny here. Jenny J. You see it, Angie?
Yes. Please unmute. Is this Miss Wong?
I'm doing my hand. I mean, no, which hand is it?
Is this Miss Wong?
Yeah, I'm here.
Okay.
All right.
Let me promote you into the well. Hold on.
I think she is in the well. She wasn't.
I just allowed her to talk because the screen name was different.
Okay. Okay, can you hear us, Ms. Wong?
You need to unmute. Miss Wong, you're still muted.
You have to unmute your microphone.
Okay, I unmuted it.
Okay, good.
Okay, I will call the case.
This meeting is being recorded.
Calling civil action 19-5370, Wong versus City of Clear Lake et al. Counsel, please state your appearances for the record, beginning with pro se plaintiff.
Ms. Wong, can you hear us?
Yeah, I can hear it.
Okay,
Yeah.
great. All right, we can see you now.
Oh, yeah.
Thank you. And Mr. Larson, are you?
Yes, Your Honor. Shane Larson with the law firm Jackson Lewis, representing defendant City of Clear Lake.
Okay, we don't have a visual on you. We hear you.
My camera is open. I'm not sure if there's anything I need to do on my end. Oh, let's try this.
There you
That's
go.
it.
All right.
I apologize. I apologize.
Okay, we're all here. Thank you. I want to talk about ADR. I know there's going to be a need to do some discovery before that. It sounds like Ms. Wong would prefer a magistrate judge as a forum. Do you have any thoughts on that, Mr. Larson? Do you have any objection?
As a forum for ADR is for proceeding with this case.
ADR, or if you all want to proceed with this case. That's,
No, I understand
that too, but
I don't know that we necessarily have an objection with a magistrate when my client views the time is appropriate. Although we're always open to ADR, we've had some, without disclosing the substance, we've had some conversations regarding settlement, and the difference is so vast that we believe some type of discovery would be necessary before ADR would be efficient.
yeah. Well, I'm going to talk about that next, but I just want to see, in terms of the vehicle, whether you believe that a magistrate judge, as opposed to, for instance, mediation, E&E.
I would say that we typically would hold to a private mediator would probably be our best avenue. Although if the court were to direct us towards a magistrate, we wouldn't object.
All right. Ms. Wong, how do you feel about a private mediator as opposed to a magistrate judge? Do you have any feelings about that?
I prefer magistrate judge.
Okay. Well, that I think, given the dynamics here, that may make sense to for me to assign this to a magistrate judge. I won't do that yet until we now talk about when and what needs to be done before then. So, Ms. Larson, what kind of discovery do you need to do just to prepare for mediation, not for trial, but just for mediation?
Sure, and just for the court's awareness, we have made an offer to the plaintiff to stipulate, to allow her to amend her state court claim to add the Equal Pay Act. We would waive statute of limitations objections or anything, so that this could be consolidated in one case with the state. She hasn't given us an answer on that, but just for the court's awareness that discussion's ongoing.
Okay.
As to discovery for the ADR, at a very minimum, we would need to have some interrogatory responses and a day of deposition.
Okay. And one deposition of the plaintiff, one day of the plaintiff, right?
Correct.
All right. Ms. Wong, in order to prepare for a settlement conference, what kind of discovery do you need?
Your Honor, we have some talk actually on the settlement. So because we've been amend complaint, so they have quite a bit of facts there. So for I think we can honor ADR on ADR, since we do have some settlement talk. And I did actually send the discovery request. Actually, even per 71, Rule 71. I think they provide something from first Rule 71, and that's a good start. They should provide much they can. Actually, I've been asked them in June and July.
What can you give me an example? What specifically would you like to see from their files?
Because I was kicked out, so I don't even have any handbook, and those basic rules about performance job requirement. I don't have those, so I need those. So because relate to the nature of so sudden of the discharge and other report of the harassment. So I needed those basic handbook and job description, all the stuff like that.
What about your employment? Do you have your employment file?
I don't have any because they kicked me out so quickly. So I mean, I even have personal stuff still there. So I don't have any stuff.
Your Honor, this is counsel for defendant. We have sent over, as part of the initial standing order of the court, the entirety of her employee file, as well as the city's manuals and other policies. They were sent via file sharing link due to the volume, and also due to the COVID difficulties printing and mailing these days. And we've asked in an email if she had any concerns or questions opening the file sharing link to let us know, and we would either resend or provide in another way. I'm happy to meet and confer with her again to see if there's a way that those documents are, if she hasn't been able to access them, that we can make them accessible. But we have produced the entirety of her employee file and also city's policies.
Okay, I very appreciate it, respect attorney. I really maybe I didn't see it. Maybe went to the junk mail. I will check again. Yeah, I will meet agree with you. Yeah, that would
Okay.
be helpful. Yeah.
All
We'll
right,
see to it
let-
that it's accessible.
Why don't you see if you make sure that Ms. Wong has access to that? Does that include all communications between Ms. Wong and the defendants? That's one of the things that's normally producible under Rule 71E.
Sure. Yeah. So the communications that we've produced would have been anything that was basically memorialized or in some kind of a form of documents, particularly during her recruitment. She was only employed with us for approximately 6 weeks, so there's not many. We're also doing a data poll of electronic communications to see what, if anything, may exist that has not already been reviewed.
All right, so you'll produce that.
Absolutely.
Fine. All right, why don't you make sure that Ms. Wong can hook up to that repository, and so she can have access to all that. Do you need to do, once you have that, is that enough for you to go to a magistrate judge, Ms. Wong, to try to mediate this case?
Yeah. So those are start basically. The document for the Rule 71 is a start. Yes.
All right. So I'm going to refer this to a magistrate judge. I think within 90 days should give enough time. Should give enough time for the defendant to issue its set of interrogatories, and I ask you that it be focused interrogatories, not broad contention interrogatories, that sort of thing. Be very focused, and to take a one-day deposition, up to 1 day, of the plaintiff. The plaintiff will be entitled to all the documents that are required to be produced under Rule or General Order 71. That includes of course, the handbook, job description, personnel file, and any evidence of communications between the parties. And that should be enough for you to have a meaningful, hopefully a productive session with a magistrate judge. We will see who's available, but I think we can get somebody available within the next 90 days. And then what I'd like to do is then for you to report back to me, the both of you, 120 days out, Angie, for a date.
Your Honor, if I may, just on the timing, I'm a member of the Army Reserve, and I do have training coming up in September that could delay my calendar.
Okay.
Would it be possible if I request this to be 120 days instead of a 90-day out?
Yeah, in view of your potential unavailability, I think that's fair. So let's have a status conference shortly after the 120-day period, maybe 130 days or something like that, Angie. A solid, you're muted, Angie? Yeah.
That would be December 17th, Your Honor.
Okay, December 17th. I will get out an order, starting the process to have a magistrate judge assigned. But I do want to make sure you go into that with enough information and so everybody's time is well spent. And then if the case does not settle, at that point, I'll have to set trial dates or figure out dates. Well, all the dates, including summary judgment and trial dates and everything else.
Understood, Your Honor.
I'll think I'll wait and hope that you all can see if you can come to a resolution with the help of a magistrate judge.
Understood.
All right.
Your Honor, I have another thing I need to bring up, and defendants say the individual may not get served, and in the Fed doc that shows a marshal served with them together to the city. So is there anything else we need to do on this part? Oh, it's done.
Okay, so it looks like it says two individuals have not been served, Mr. Heron, Mr. Folsom, is that right?
But it's served by the court marshal, and if we look at the court doc, and they didn't put on they serve them to the party they work the city together, right? So that's the way normally do when the marshal does that.
Your Honor, for clarification, the two individuals are no longer employed by the city and were not when she filed. So
right, so
the city,
they weren't at the office. They weren't at the office then. they're not employed.
No, they're no longer employed and wouldn't have been at that office.
All right, so they have to be served individually then, correct?
That's correct.
Your Honor, so in this case, the marshal, what the marshal should do, go give to the attorney. I mean,
No, well, you might want to talk to our help desk about how do you serve an individual. Normally, you have to personally serve them at their home, their business. You have to find them. There are other ways. There's substitute service. If you try to, for instance, go to their home and nobody answers, at some point you can leave a copy there and then mail it. There are rules. I don't know if you have our manual for non-represented litigants. There's a whole section there about how do you serve an individual. You might want to look at that. You might want to call or talk to our help desk. But unless they're directed, for instance, unless you have the address, the marshals are not, I don't think that they're going to be able to just go out and find them. I think you have to give them some information.
well, in that case, maybe the local publication then, because because of the marshal is even more,
I can't give you advice about whether publication notice is enough. That probably is not enough, is my guess. And we have the problem now. I'm not sure how much service the marshals are doing with the pandemic. They are so swamped with all the issues in the jails and everything else. I just don't know. It is a problem right now. That's why I would suggest that you talk to the help desk, tell them your situation, see if they have any ideas how you might effectuate service. And I don't know if Mr. Larson, if the city has the last best address that may be required to be produced in order to find them. So
Understood.
So that's what I would advise, Ms. Wang, is to try to get some help on this, because this is complicated, and I don't think you just give them to the marshals and say serve these individuals. It's more complicated now that these people have left. But I believe that I think it would be fair to ask the defendant if they have the last known address of these two individuals to give that to you. So I will leave that to you.
I'll get that. That'll be part of the requirement, needed for the settlement too. Yes. Okay.
Yeah, that'd be advisable, and I would again ask you to try to contact the complaint desk as soon as you can.
Okay.
Our help desk. Yeah.
Yeah, I get from the defendant to the attorney.
All right. Then I will see you at the next calling of the case on December 17th. All right.
Thank you, Your Honor.
All right.
Thank you, Your Honor.
everyone. Thank you.
Thank you.
Court is adjourned.
The recording has stopped.
Mr. Kyle, you had your hand up?
Yes, ma'am. John Kyle and I represent Percipient.ai, and we had pursuant to, let me see if I can get this order. Judge Chen had continued a status reference in our matter out for today, but in the meantime, he had so it was in our case. The case number is. I'm looking at the document. Right
Yes, I had looked it up. Did you get my email?
I did not.
Okay.
I did not. So it went out. Seemingly it went off calendar.
Yes. This was erroneously dismissed, and at that time, it terminated the status conference. So And when we put it back on, I neglected to see that. So
We have a hearing set on the motion to dismiss for September 3rd.
That's
So I just
correct.
wanted to make sure that, I wanted to be on in case the case got called, because I didn't see anything that vacated difference. And so,
No,
so anyway,
we will probably reset the status to go to be alongside the motion hearing.
okay, very well.
All right.
Thank you much.
Thank you.
Bye-bye.
Kathy, can you hear me? To the attendees, the first case we're going to call today is Slack Technologies. If you are participating in that case only, please raise your hand right now. Your raised hand feature is at the bottom of your screen.
Good afternoon.
Good afternoon. Any other counsel participating in this case? Please raise your hand.
Not from, I'm here for Foji, the defendant.
Okay.
There will be counsel from Slack, I assume.
Okay.
Hi, this is
Good.
Amit Modi for Slack.
Good afternoon. So you two should be the only counsel in the case today?
From Foji, that's right.
And for Slack, that's also correct. One person from my office, I believe, will join simply to observe, but I will be the only one speaking.
Okay, great. All right. Well, we will start sharp at 1:30.
Sounds good. How are you, Amit?
I'm well, Eli. How are you?
I'm good, thanks.
It's 3:30 your time, is that correct?
Right, yep. So you're out in California now, right?
I am, yeah.
Yeah.
Yep. As you said, taking the bar exam mid-career, not fun.
Yeah, I was wondering if maybe you were going to tell me that they had changed the rules or something, but apparently you still have to take it.
Yeah, I heard that they changed the rules for this next upcoming exam insofar as they lowered the passing score. So.
Oh, is that right?
I wish I had the benefit of that, but that's okay.
Do you know if the latest test people did in person or did they do it remotely?
Yeah, I think the most recent one was February, which was in person.
Oh, okay. So they haven't, did they have one scheduled for the summer?
Yeah, there was one scheduled. I think it was supposed to be last week, and
right.
That was taken off calendar. And I think the current plan is to do a remote test on, I don't know, early October sometime.
Okay, gotcha. Yeah, I was just thinking about when I took it in a giant auditorium in Sacramento, and I don't think it would have been very good for social distancing requirements these days.
No, absolutely not. It was, I had the same experience, and it's a lot of people in one room.
Mm-hmm. Do you find the headphones make a big difference for these things?
You know, I do it partly because I've got my kids not too far away. So it's perhaps for my benefit more than anybody else. But yeah, I think so.
Yeah.
I've heard both ways. I've heard that my voice comes through more clearly with the headphones on, but you know, sometimes I'll have pairing issues, or you know, either Zoom or WebEx or whatever application I happen to be using won't recognize them. So, you know, if I throw them off mid-hearing, you'll know why.
Gotcha.
How about you? Do you kind of just go without the headphones?
No, yeah, I have. Yeah, I've just so far just been using sort of what my computer has available, and it's worked okay. I did try just normal headphones once and it didn't work very well, but it wasn't especially well planned out. So,
Right.
you know, most of these that I do are fairly informal. I mean, I've had hearings and depositions and stuff, but they're not happening every day or anything.
Sure.
I'm going to be teaching a law school class in the fall, and I may need to more seriously consider upping my technology game for that.
Yeah. Yeah. You know, the one downside is for a class or deposition or something, like I've taken a couple depositions with these, and after a while.
Good afternoon, everyone. Just a few short announcements. When you are not speaking, please mute your audio so that it's easier for the court reporter. And to everyone, any other recording of this proceeding, either by video, audio, including screenshots or other copying of the hearing, is strictly prohibited by the court. So, Your Honor, if it's okay to get started.
Yep.
This meeting is being recorded.
Court is now in session. The Honorable Edward M. Chen is presiding. Calling civil action 20-1509, Tsca Technologies, Inc. versus Foji, Inc. Counsel, please state your appearances for the record, beginning with plaintiff's counsel.
Good afternoon, Your Honor. Amit Modi from the law firm of Damaris LLP, representing the plaintiff Tsca. On the line from my office is Emily Chen, and also from Tsca is Cindy Wheeler, who is the Senior Director of IP at Tsca.
All right, thank you, Ms. Modi.
Good afternoon, Your Honor. Eli Van Camp appearing on behalf of the defendant, Foji, Inc. One of my colleagues from my law firm, DeWitt LLP, Eric Chadwick, may also be attending through the public function.
All right, great, thank you, and welcome. There is no dispute, I take it, that as far as choice of law goes, over the question of personal jurisdiction, that this court has supplied federal circuit law, correct?
Correct.
Okay. And my understanding of the federal circuit law, which is not unlike most circuits, but there are some nuances here that may be material, is that we look at three things. Does the defendant purposely direct activities, or has it purposely directed activities at foreign residence? And whether the claim arises out of those or relates to those activities. And finally, if so, whether the assertion of jurisdiction is reasonable and fair. It's pretty clear that where there is a fairly specific threat of litigation, and I understand that the purpose of this was try to induce the plaintiff into entering a license, but you know, as we've looked at all those cases involving the question of Article III jurisdiction and what constitutes sufficient threat to confer jurisdiction for Article III purposes, this is the kind of case where you would find that, because there were numerous letters, numerous correspondence, thinly veiled and sort of non-veiled threat of litigation as the obvious alternative if the license is not entered into, if negotiations fail, claim chart, et cetera, et cetera. So it seems to me that those cases that find that a sort of specific and concrete threat of litigation, particularly where there's a series of letters, emails, telephone calls, et cetera, it is enough to satisfy that first factor. And clearly this claim arises out of that, so there's no real doubt about that. From what I see, the real question is the third factor, whether assertion of jurisdiction here would be fair and reasonable. And this is where I'm trying to understand the federal circuit law. It seems to suggest, when you look at the cases, that what the courts look to, absent enough activity to constitute sort of general jurisdiction, you know, such systematic and continuous business that you're almost a resident, That's not what we're talking about here. That when you look to the other that the contact alone is generally not enough with the one, plaintiff, the declaratory relief plaintiff, or the substantive defendant. But you look at other activities in addition to the threat of infringement, and it seems like the cases that find sufficient activities are ones where it's not just general business activity, but activity that is related to the patent, either enforcement of the patent or some other aspect of the patent that issue here that is required. The activity can't be just general commercial activity, for instance. And Jack Henry is a case where, I guess one of the most recent cases, where the circuit court found it was reasonable, it wasn't a burden on the defendant, and there wasn't a lot of analysis, but the fact remains, in that case, as I understand it, there was multiplicity of lawsuits that were brought by the patent holder. And similarly, in some more recent cases, there's activity that is related to the patent that constituted. I mean, in Jack Henry, there are it involved 11 plaintiffs' banks that all had been subject to cease and desist order. And in the Xilinx case, there was previous litigation of 7 patent infringement suits in the forum state. And here, I don't see other accused. I don't know if I don't see any record of any activity brought or threats brought against other potential putative infringers here in California. And unless I missed something in the record, but that seems to be the issue. Is there enough? I understand, the involvement with Apple and Google and the trip out here and some of the other commercial activities, but they don't seem to be connected with enforcement of the patent. And that's where the issue seems to be.
Your Honor, this is Amit Modi for Slack. Perhaps I can, with Your Honor's permission, address that first.
Yes.
Two responses to Your Honor's comments. I think, as Your Honor noted, clearly there was a clear assertion of this patent against Slack, and the claim arises from it. So the minimum context prongs are satisfied. What distinguishes this case from some of the others I think Your Honor might have in mind is that there is no question that there are a number of activities that FOGI has conducted in the state of California that are, at least according to FOGI, specific to this patent, right? There's not, for example, a dispute, at least from FOGI's perspective, like there was in Petzilla over whether certain activities that were conducted in the forum actually had a tie to the patent. I believe Petzilla was Your Honor's case where the activity that was being conducted in the forum had to do with treat packs, and the issue was that the patent in suit had nothing to do with treat packs. It was a dispenser. By contrast, here FOGI itself concedes that it has engaged in a number of activities in California using California businesses, and all of those activities directly relate to an application that FOGI contends is practiced by the patent. So there is a tie, this is a patent case. Slack's claim relates to the 149 patent, and all of FOGI's activities in California that are alleged in the complaint are, according to FOGI, directly related to the 149 patent.
It's related to really its commercialization of the patent, but not to any alleged infringement of the patent.
Your Honor, I actually think it depends on what those activities are. First of all, FOGI has contended that all of its activities are so-called commercial activities. Of course, it also contended that its interactions with Slack were commercialization activities, which I think, as Your Honor noted, is not a fair characterization. But a number of the facts that Slack has alleged in its complaint have also, I think, demonstrated that FOGI has attempted to engage others to, at least to take an implied license to its product, which it contends is covered by its patent, right? The ability to use a product at the behest of the patent holder is effectively an implied license. So
well, does that apply to Apple and Google? They're just a distributor, right? They're just an outlet. They're not using they're not.
We have alleged in the complaint on information and belief that Apple and Google are permitted to distribute FOGI's app. In other words, to provide it to the public. I think FOGI argues that that's not a sale under the Patent Act. That's not my understanding of, a sale doesn't have to constitute an exchange of money. And to the extent that FOGI, under its agreement with Apple, for example, has provided Apple with the right to distribute to the public what it calls a patented app, then it has implicitly licensed Apple to that right.
Well,
Your Honor,
some cases put some premium on, sort of allow that if there is an appointment of an exclusive distributorship, like in genetic implant. I mean, then you have an ongoing relationship. It's, you sort of assume that there's going to be, when you have an exclusive distributorship, there are things you have to monitor. There's an ongoing relationship. If it's just a non-exclusive license, the nature of that relationship is not as sustained. And so there's some distinction there. Is there not, between exclusive and non-exclusive distributorships?
I agree that there's some distinction between exclusive and non-exclusive. But Your Honor, I would argue that I don't think the Federal Circuit has made that a requirement for personal jurisdiction under the due process factor, that there be some exclusive relationship or that there be some sort of ongoing obligation. In fact, Your Honor, we cited the Xilinx case. I think that's instructive here. Xilinx v. Pabst. This is 848 F3rd 1346. This is a 2017 case from the Federal Circuit. And at page 1355, it explains that the inquiry under the reasonableness prong, which is the due process factor, is not limited to the specific facts giving rise to or relating to the particular litigation. And then it quotes the Burger King, which is the Supreme Court case. Once it has been decided that a defendant purposefully established minimum contacts within the forum state, these contacts may be considered in light of other factors to determine whether the assertion of personal jurisdiction would comport with fair play and substantial justice. So my point, and the Xilinx court's point being, Your Honor, we're considering due process now. Is it fair, given that FOGI has purposefully directed activities at California and SLAC's claim arises from those? Now the question is it fair, given the totality of the other circumstances and facts that SLAC has alleged, that FOGI be called into court here in California? And I would submit that the numerous contacts that SLAC has alleged in its complaint more than satisfy that reasonableness prong, particularly given, as the Supreme Court has said, it is FOGI's burden to demonstrate a compelling case that being called into this court would, offend the traditional notions of fair play and substantial justice, and they simply cannot do that. FOGI has traveled into
the burden is on FOGI to show that it is unreasonable, right?
That is correct. That is correct.
And the test, as articulated in Jack Henry, is that it's got to be unduly burdensome.
I believe that is the phrase used.
I mean, that's the general focus. At least that's certainly what Jack Henry focuses on. And I guess your argument would be, well, all right, even if it's not an exclusive license, even if there's not, I guess you would admit there's no evidence of any enforcement action per se. There are no other parallel actions like this in this that you know of.
We don't know of any other parallel actions. I suppose the minute FOGI sends one additional letter like it did to SLAC, that would, I would submit that shouldn't change the analysis. But Your Honor, to answer your question, we're not aware of any other threats like they threatened SLAC.
So your point is given the extensiveness of its contact, I guess, first up would be Apple and Google. Is that the primary demonstration of lack of birth? Now, let me ask you, was there a form selection clause in the Apple contract?
Your Honor, we don't have the Apple contract. We alleged on information and belief that, and in fact, FOGI concedes in its CEO's declaration that there is a license agreement between Apple and FOGI. We don't have a copy of it, and it was a little surprising that FOGI didn't attach a copy of it. But nevertheless, it is our understanding that there are certain rights that there are certain provisions to which FOGI has agreed. One of them being, to Your Honor's point, subjecting itself to personal jurisdiction in the Northern District of California for any disputes arising out of that agreement. Yes, Your Honor.
You've not seen it, but you have reason to believe that there's a personal jurisdiction waiver provision.
Yes, Your Honor, and let me clarify that. I believe Apple makes available on its website sort of the form agreement, and based on that form agreement, we understand there is this form selection clause. The specific agreement that FOGI and Apple entered into, we believe, is that agreement, and that's what we've alleged as a factual matter. And we have not. I don't believe FOGI has contradicted that in any way.
And what about with Google?
It was our understanding, Your Honor, that Google similarly has a form agreement that a developer like FOGI would enter into. I understand from FOGI's papers that they deny having entered into any agreement with Google. And so I suppose on that issue, there is a factual dispute. I would submit that on the pleadings, factual disputes, of course, are resolved in the on a motion to dismiss, are resolved in the favor of the in favor of the non-movement.
All right, Mr. Van Camp, I'd like you to respond, and in particular, how are we supposed to evaluate these other activities? Do they have to be? Are they limited to be cognizable? Do they have to be limited to either enforcement activities against potential infringers, or an exclusive distributorship or licensing as opposed to a non-exclusive? And what about just general other activities?